Hello world, welcome, or welcome back. I'm Goddess Dawn. It's Wednesday, October 2nd, 2019, and I'm back with an R. Kelly update. As I'm sure you now know, Sylvester, is what I'm calling him now, he had a hearing this morning where his bond request was addressed and denied. I did a live last night and read the original motion for detention from the prosecution, which was filed on July 12th, as well as R. Kelly's letter to the judge, a motion his attorneys drew up and filed with the court on September 30th, Monday. In that video, I predicted the judge denying bond, and I know everyone in the chat agreed with me, or at least were hopeful. Well, we can breathe easy knowing that Sylvester will remain behind bars pending trial, which was set for May 18, 2020, almost directly following the state Illinois trial set for April 27, 2020. He faces the Illinois federal court on October 8th. I believe he's required to be present. I'm going to read the short or the condensed version of the minutes from today's hearing. It says, minute entry for proceedings held before Judge Ann M. Donnelly, status conference as to Robert Sylvester Kelly held on October 2nd, 2019. Appearances by, and it names all the attorneys that were present on both sides. It says that the case was called, a discussion was held, defendant's appearance was waived, motion for release was denied. Jury selection and trial was set for May 18, 20 at 9:30 a.m. Motions in Lamine are due by April 13, 20, and oppositions are due by April 27, 20. The parties' joint requests to charge, voir dire, and verdict sheets are due by May 4th, 20. Final pretrial conference is set for May 14th, 2020. Next status conference is set for December 9th, 2019 at 4:30 p.m. And there you have it, straight from the court records. Basically just a short and sweet summary of what happened at the hearing today. It lays out future dates for hearings, trials, jury selections, and as well as due dates for motions and such. I also have in hand the prosecution's answer to the bond motion that was filed by the defense on Monday. They waited until the last second to file it, which was smart of them. And here are some of the points for some of you who may be confused about his being detained and wanting to know what the judge was thinking. So the letter addresses the judge, and it says, pursuant to the court's September 30, 2019 order, the government respectfully submits this letter in opposition to the defendant, Robert Kelly's September 30, 2019 motion for pretrial release. For the reasons set forth herein and the government's July 12, 2019 detention memorandum, a copy of which is attached hereto, the government respectfully submits that the order of detention issued by the Honorable Stephen Ticione should remain in place and the defendant's motion for pretrial release should be denied. Okay, so that's basically them letting the judge know, look, we already set out a memorandum in July 12th specifically, and we're going to attach it here, but we are going to address everything in the bond request so that we can make sure that he stays behind bars. So it goes on to talk about applicable law, because the defense attorney, first thing he talked about was the applicable law doesn't apply with Robert Kelly. They go on to talk about why they're warranted. It says the defendant appears to question the government's motivation for bringing the charges in this district and suggests that they may not be legally sound. In fact, the defendant is facing serious charges in the Eastern District of New York for no reason other than there is significant evidence that he committed serious charges in this district. A grand jury has returned an indictment charging the defendant with racketeering and other serious crimes relating to criminal activity committed over 2 decades. Notwithstanding the defense's unsupported claim that many of the racketeering allegations arguably do not even fall within the definitions found, each racketeering act squarely qualifies as a predicate racketeering act under that section. Now, basically, they go on to talk about why that motion that Greenberg submitted or filed is wrong. It literally says he is wrong by saying these things. It says the defendant also suggests that because the description of the enterprise and its means and methods include some lawful behavior, there are serious questions as to whether the present indictment will even stand. It says he's wrong. And it continues to reference back to the original detention memorandum, which is what got him detained in the first place. They go on to talk about why he still poses a serious flight risk. And it says that as an initial matter, the defendant's appearance at that prior court proceedings in connection with his 2002 Cook County case is hardly indicative of whether, if released, he would appear in connection with this case. He's facing substantially more time in prison than he did in connection with his 2002 case. Moreover, in connection with his 2002 case, the defendant paid witnesses a substantial sum of money to ensure that they did not testify against him, greatly reducing the likelihood of a conviction and therefore his incentive to flee. Second, the defendant's argument regarding the lack of international travel is misleading. While the defendant may not have traveled internationally in recent years, it is not true that he lacks the ability and desire to do so. Indeed, this year, after he had been released on bail in his current Cook County case, he sought to travel to Dubai with his 2 living girlfriends, each of whom took steps to accompany him by submitting applications to obtain their own passports. Indeed, his desire to travel abroad is likely even higher given his diminished stature here in the United States. Ooh, shade. This is another factor that demonstrates his risk of flight. So yeah, they go on to continue to describe reasons for him to continue to be detained. It says that the government credits the defendant's claim that he surrendered his passport to authorities in connection with his release on the current Cook County case. This, however, does not prevent him from obtaining a duplicate passport, and as described below, his prior actions have shown that he cannot be trusted to follow an admonition by the court not to do so. Like he's just gonna listen to the court. Yeah, right. The letter goes on just to say that, the defendant's contention that he has almost no financial resources is also misleading. In fact, the defendant continues to receive hundreds of thousands of dollars in connection with royalties he is owed for his music. The government's investigation has revealed that earlier this year, the defendant redirected those royalties to a bank account of a childhood friend. Regardless of where those funds are being held, however, they belong to the defendant, and at any time the defendant can redirect those funds and future royalty proceeds earned to an account in his name. His lack of candor with the court regarding his financial resources is another factor that counsels against release. This letter goes on and on and on. I think what I'm going to do is just talk about the rest in the live I'm going to do this weekend. I wasn't planning on making a really long video tonight. I just wanted to just put a stamp on the fact that there was no bond today at the hearing. And, but wait, did I say no bond? No bond. Bond denied in the New York court today. Just want to make it clear for the people who can't hear me over the crying of the beehivers. No bond. And with that said, I'm going to leave it here. Let me know your thoughts in the comments. Go ahead and subscribe if you haven't done so. All of that. Like the video. Until next time, peace.